Mr. Speaker, continuing with the calendar, page 20, House bills on second reading regular calendar. House Bill 706, a bill to amend the Code of Virginia relating to member of the General Assembly standing to defend laws of the Commonwealth. Emergency, report from the committee for courts of justice with amendments, and there is a floor substitute as well.
The gentleman from Shenandoah, Mr. Gilbert.
Thank you, Mr. Speaker. Mr. Speaker, I just reserve the right to act on the amendments in just a moment. The first thing I'd like to do is just explain the bill. This was put in before any of the recent controversies now surrounding our Attorney General. And it was put in, I suppose, based on some statements that the Attorney General made on the campaign trail alluding to the notion that he may well decide not to defend a particular law or constitutional provision were he to be elected. Just 2 weeks into, under 2 weeks into his term, Mr. Speaker, we heard the Attorney General not only say that he was not going to defend a provision of the Constitution that was passed not only by this legislature but by the citizens of Virginia, but that he was going to act in a manner that was contrary to that constitutional provision and actually essentially come in on the other side of the issue. Mr. Speaker, the hypothetical situation that we faced when I put this bill in, where an Attorney General would not only decide to not fulfill his role, but also not appoint other counsel to fulfill it, where the governor would then also decline to provide counsel to defend a constitutional provision, that was at the time purely hypothetical, and we are now in the middle of that very stark reality where a provision of Virginia's Constitution passed by this body, by the Senate, and by the people of Virginia is not being defended by our Attorney General or our governor. Mr. Speaker, when we pass a law, we expect that our attorney will defend it. We expect more than that, that the Constitution of Virginia will be upheld. It is the Constitution of Virginia that the Attorney General and Governor swear to defend. There have been comments made about, well, didn't Attorney General Cuccinelli do this? Well, he decided that a particular law that we passed actually violated Virginia's Constitution. And in that regard, he stood up for Virginia's Constitution, which trumps any law we pass. In this case, our Attorney General has decided not only not to defend our Constitution, but to actually act against it. I want to take the immediate politics and the immediate concerns that people have to circle the wagons on both sides and sort of look at this from a partisan point of view and just point out to the body that this bill long term will have great bipartisan implications, not only for the members of these bodies who pass our laws, but for the people of Virginia who elect us to do so. In any situation in the future, regardless of which party controls either body or regardless of which party is in charge in the governor's office or sits in the Attorney General's office, we, the legislature, should have the ability, when we pass a law or a constitutional provision that is later enacted by the people, to defend that where no one else will and where it is actually their duty to do so. This is not a position that any of us should ever have to be in, Mr. Speaker, but we find ourselves in the very position that the bill contemplates at the moment. One wonders if this is the end of the controversy along these lines. We are only 2 weeks in when the Attorney General makes this decision. What other aspects of our law does he find, hold in disfavor? What other aspects of our Constitution will he choose in the future not to defend? There are lots of things in our Constitution that all of us would agree are controversial, and there are lots of things that are not, but now the Attorney General of Virginia can pick and choose what he thinks personally is important to defend, and I think that is an untenable position to be in, Mr. Speaker. And for that reason, I put the bill in advance, hoping this day would not have come, but it came all too quickly, and it appears we have lots more time to find out what our present Attorney General finds, where he finds fault with our Constitution. And so in order to proceed with the debate, I would move that I think there's a floor substitute, Mr. Speaker. I would ask that the body reject the committee amendment, and that there is a floor substitute that contemplates the floor amendment and another concept as well.
The question is on adoption of the committee amendments. As many as favor that motion will say aye. Those opposed, no.
No.
Committee amendments are rejected. Has the floor amendment been distributed?
Mr. Speaker, just speaking to the floor amendment briefly, then I'll yield to the gentleman from Prince William. Mr. Speaker.
Mr. Speaker, parliamentary inquiry.
Gentleman from Charlottesville, Mr. Scott.
Thank you, Mr. Speaker. I'd ask the chair, we have two different amendments here that have been passed out, and so I'm not sure what the gentleman from Shenandoah is referring to. So are we referring to the so-called replacement floor amendment, just for the clarity of the body?
Yeah, that's an amendment in the nature of substitute.
Mr. Speaker, the gentleman may have two versions of that amendment in the nature of a substitute. It would be the one with the not one but two scribbles on it, the one preceding and then the one within the body of the text in the last part.
That says replacement. Yeah.
Mr. Speaker, the gentleman from Prince William is trying to help put this in a better posture. I'm going to ask the body to accept his amendments, and I'll yield to him to explain the reasons.
Gentleman, Prince William, Mr. Marshall.
Addressing the substitute.
Gentleman has the floor.
Thank you, Mr. Speaker. Excuse me. Some people contend that an individual member of a legislative body would not have standing when it comes to formal actions. Now, my amendment changes the underlying bill somewhat in that it also allows those people who will be designated to have standing to address a challenge to the Constitution. The original statute proposed by our colleague from Shenandoah limited to plain statutes. I've added that provision. But just to give you confidence that, in fact, an individual legislator can have standing, or a collection other than the body, I'm going to refer to you Coleman versus Miller, 307 U.S. 433, 1939, in which a divided state Senate in Kansas, 20-20, tie on ratification of the child labor amendment, which, by the way, is still pending because no time limit was put on it, and 28 states have ratified it. The lieutenant governor broke the tie in favor of the amendment. This was contested by a state senator later and 23 other state senators as an invalid action on the part of the lieutenant governor, not being a member of the body, but being the presiding officer. So the question came up, and the syllabus of the case says the complaining senators whose votes against ratification have been overridden and virtually held for naught, although if they are right in their contentions, their votes would have been sufficient to defeat ratification, have a plain, direct, and adequate interest in maintaining the effectiveness of their votes. They have set up and claimed the right and privilege under the Constitution of the United States to have their votes given effect, and the state court has denied that right and privilege. Ultimately, the Supreme Court in this decision held that this was a political question and did not decide on the merits, but they did not conclude that the state legislators lacked standing. Now, the difference in this, as I mentioned, this would allow a provision of the Constitution which is not being defended either by the governor, and 53 of us requested him to do that, and he declined, or the Attorney General, and we know what he's done with this. It allows either the entire General Assembly to file suit, or the House, or the Senate. Is there precedent for this? Well, yes. When DOMA, the Defense of Marriage Act, signed by one William Jefferson Clinton in the middle of the night, was challenged and was abandoned, made an orphan. There seems to be a habit here among Democratic attorney generals to pull a switch in the middle of the night. Mr. Holder abandoning his oath of office and then, leaving DOMA an orphan in the courts, and Mr. Herring, I guess, taking his cue from Mr. Holder, but going one beyond, not just leaving the people of Virginia an orphan, but leaving them a pariah to be attacked So all this does, it gives standing to the body. Where's the example? Speaker John Boehner. When no one was defending in federal court the Defense of Marriage Act, filed suit on behalf of the House of Representatives. In this case, this speaker could file suit to enter court in this instance of this constitutional amendment or another point in which a governor or attorney general, I see he's anxious to do this, do not defend the laws of Virginia. We do not want to end up in a situation of the people of California who voted for Prop 8, including minorities in overwhelming numbers, only to be abandoned by Governor Schwarzenegger and Attorney General Brown. Nobody was defending the people of California in the U.S. Supreme Court. You do not want that. Well, I don't want that situation. Mark Herring apparently is very satisfied that the people of Virginia will not be represented. So I ask you to support this substitute.
Mr. Speaker.
This is nothing radical.
Mr. Speaker.
Gentleman Fairfax.
Would the gentleman yield for question?
Will the gentleman yield?
Yes.
Is the gentleman contending that there's nobody in the state of Virginia defending Virginia's constitutional amendment?
The state of Virginia is not defending the people of Virginia. Yes, I affirm that.
Mr. Speaker, I would ask the gentleman what the officer,
I'd like to ask him a question.
Yes. Further question, Mr. Speaker. I apologize.
Will the gentleman yield?
Yes.
Gentleman yields.
Is the gentleman suggesting that the person from the Office of Vital Records and I can't forget her, I can't remember her name, and the clerk of Prince William County are people who can defend the law of Virginia?
The clerk, Ramey, and Michelle McQuigg used to be a member of this body. Delegate, I guess now Circuit Court Clerk McQuigg asked to intervene, was granted, but they are being represented by Alliance Defending Freedom, a private litigation group. They are not the Commonwealth of Virginia. They're not paid by the Commonwealth of Virginia. They were not retained by the Commonwealth of Virginia. They sought to intervene to do it, and they have been granted the ability to represent. But the Commonwealth, because of the actions of this Attorney General and the refusal of this governor to defend the people, is left an orphan in the court.
Thank you, Mr. Speaker.
Gentleman, continue. You through? Questions on adoption of the amendment in the nature of a substitute, floor amendment in the nature of a substitute. As many as favor adoption of the floor substitute will please say aye. Aye. Those opposed, no. Amendment's agreed to. Gentleman from Shenandoah, Mr. Gilbert.
Mr. Speaker, I move that the bill be engrossed and passed to its third reading.
The gentleman from Henrico, Mr. Morrissey.
Thank you, Mr. Speaker. Mr. Speaker, speaking to the bill.
Gentleman has the floor.
First of all, let me address some of the comments that were made, not in reference to House Bill 706, but much more political in nature, talking about orphan and pariah and dereliction of duty and failure to protect the Constitution. Let's be clear about something, first of all. The Attorney General is, first and foremost, that individual there that is to protect the interest of Virginians. He is also the attorney to represent various state entities and institutions. Now, my friend from Prince William County and from the Shenandoah Valley talked about not protecting the Constitution. Let's be clear. The Attorney General of Virginia, just like Generals Cuccinelli and McDonnell and Terry and Early and Belials, have always said, this is nothing new, we will protect the Constitution of the United States as well, and indeed, they take that oath. General Herring has said that the 14th Amendment due process rights and equal protection rights are being infringed upon, and that is why he has opted not to defend this particular law. And it's no different.
Mr. Speaker.
Not,
Gentleman Prince William.
Would the gentleman yield for a question?
not at this point, but when I'm finished, I will, Mr. Speaker.
Gentleman declines to yield.
General Herring is doing nothing different than the other attorney generals have done. Indeed, as the delegate from Prince William County noted, General Cuccinelli decided not to defend Governor McDonald's, I think it was the Opportunity Education Institution bill, because he felt it violated the U.S. Constitution. Now, let's get back to the bill itself. Let's forget about these politics for a moment. Let's get back to 706 and have a little fun. First of all, standing. It's a simple concept. Locus standi. And it's simply the capacity of an individual to bring a suit. And state law does give and does define standing in state court. And at the heart of the matter, it's, is there an injury and is it redressable? Really simple concept. You don't have to be an attorney. If you're injured in an automobile accident, you're driving a car, somebody runs into you. Do you have standing? Yes, because you're injured and you want that redressed. That's standing. Now, what this bill seeks to do is give an individual, a member of the General Assembly, standing in federal court. What a novel concept. The state of Virginia giving somebody standing in the federal judiciary. If you ask any law school professor or constitutional scholar, they will tell you with absolute certitude that no General Assembly can give or confer standing in federal court. Spoke to a recent professor at the University of Virginia who says, quoting, in other words, the General Assembly can't manufacture standing in federal court. Do it all day long in state court. Give our lovely ladies and gentlemen up there on the dais standing. They can do it if we give them the authority. But we can't confer standing in federal court. It's like what's that little animal on TV? Geico commercial. Everybody knows that. Only Congress and the federal court can confer standing. And there has to be a direct stakeholder and there has to be an actual dispute. My friend from Prince William County mentioned Prop 8 in California. Do you know what the federal court said? The federal district court judge said, you're out of here because you don't have standing. Now, I can just see, if this bill passes, one of the members of the General Assembly here going into Judge Spencer's courtroom over in federal court to intervene in a federal matter, standing up and saying, I'm here to represent the Commonwealth of Virginia. And I can see Judge Spencer saying, on what basis are you here? The U.S. Constitution? The Federal Rules of Civil Procedure? An act of Congress? No, waves the paper. Delegate Gilbert and Delegate Marshall say I have standing. I think Judge Spencer would smile and say, no, you don't. Now, 5 times in 6 years I've stood up here and I've said a particular law is unconstitutional. I don't say this for purposes of braggadocio, but in every instance that was true and was upheld. Ladies and gentlemen, this bill is unconstitutional. If it cannot, under any circumstance, withstand a challenge in federal court. Now, think of this. There are lots of issues that come up in federal court. It's not just standing. It could be subject matter jurisdiction. It could be subject matter amount. Presently it's $75,000. Whether or not a federal question exists. Every state can't determine their own rules. Think of it this way. A New Mexico 18-wheeler hits a Virginia driver in the state of Maryland. Who's got standing? What's the federal question? What's the jurisdictional amount? Can you imagine if every state, all 50 states in our territories, had their own individual rules? It would be a quagmire. You couldn't do it. That's why we have order. That's why Congress, that's why the Federal Rules of Civil Procedure, and that's why the federal judiciary determines standing. Folks, if you do not want to embarrass yourselves, if you value the work product that you generate here, you will resist the temptation to follow my friend from Shenandoah Valley and the gentleman from Prince William County move that finger from the green to the red and say it's unconstitutional, because it is.
Mr.
Thank you,
Speaker. Mr. Speaker.
I was just about to say I'm done, and I will answer any questions, Mr. Speaker.
The gentleman, Prince William.
Would the gentleman yield for a question?
Will the gentleman yield?
I'll yield, Mr. Speaker.
Gentleman yields.
I hope I didn't interrupt his peroration here, but
If peroration is a good thing, then yes. If it's a bad
I
thing,
didn't
no.
finish the question, Mr. Speaker.
We don't have talk going back and
Yes,
forth.
Mr. Speaker.
People.
Would the gentleman like to explain how 23 senators in Kansas, state officials, were granted standing in I believe you'll acknowledge the U.S. Supreme Court is a federal court, to sue for loss of their rights?
Yes, I can.
How did they do that?
They asked the federal court, can we have standing? And the federal court granted standing. Here, we are manufacturing standing. That's the difference.
Would the gentleman like to answer who is defending? I'm sorry. Would he yield for another question? Sorry.
Mr. Speaker, I yield.
Gentleman yields.
Thank you. He says the Attorney General has arrived at his conclusion based on the 14th Amendment. I wrote the Attorney General more than a week ago. He never answered me. I have right here the compilation of all the Reconstruction civil rights laws and the debates on the 13th, 14th, and 15th Amendments. I have about 1,800 books in my personal library. Is the gentleman familiar with the debate on this point, on the 14th Amendment? And if so, where does it say that sodomy is somehow a predicate for marriage, or anything closely approximating that?
Mr. Speaker, I would tell the gentleman I don't know if his question was rhetorical, in which case I won't answer it, but this bill has nothing to do with sodomy. It has nothing to do with two consenting adults engaging in whatever activities they are desirous of doing in the bedroom. My statement and my comments earlier addressed HB 706, and I'll be happy to address that. With regard to why General Herring hasn't responded to you, hasn't responded to the gentleman, Mr. Speaker, I can't answer that. I'm assuming that he probably will. But with regard to the 14th Amendment, he has said the following, and I only know it because I have read about it in the paper. He has said, first and foremost, I am the Attorney General for the people of Virginia. Those two individuals that are desirous of marrying one another are Virginia residents. I am representing their interests. Their interests are being infringed. Their U.S. constitutional interests are being infringed. 14th Amendment right to due process and equal protection. Therefore, I am going to let the U.S. Constitution trump the state constitution. I think when he does respond to you, he'll say something along that line.
Mr. Speaker, further question?
Will the gentleman yield?
I will, Mr. Speaker.
Yields.
Who is representing Virginia right now in court who is an official or authorized by the Constitution to act for the state of Virginia right now in the instant case in Norfolk, in which Mr. Ted Olson is one of the attorneys?
I think Delegate Sickles responded earlier that right now the Commonwealth of Virginia is being more than adequately represented by those circuit courts who have retained outside counsel. I haven't heard anybody suggest that they do not have the skill set, the wherewithal, or the ability to represent the interest of the Commonwealth. All General Herring is saying is the same thing that General Cuccinelli said. I think their rights, their U.S. constitutional rights of the gay couple are being infringed upon. Therefore, I cannot and will not represent the Commonwealth.
Further question, Mr. Speaker?
Will the gentleman yield?
Yes, Mr. Speaker.
Gentleman yields.
The gentleman has represented that the prior Attorney General, as well as some others, basically conform to and agree with the actions of this Attorney General. But in fact, in those instances, counsel was appointed as provided by law, sometimes by the Attorney General and sometimes by the governor, as witnessed the fight between Governor Wilder and Attorney General Mary Sue Terry with respect to the VRS case. But in all those instances, there was representation formally appointed by someone pursuant to statute. In the absence of a statute right now granting either this body or the other body or the entire General Assembly or members, who defends Virginia?
Mr. Speaker, I would tell the gentleman that I will assume, because he said it with such conviction that he's right, the other attorney generals appointed somebody else. I don't know that, but I will accept that as a fact. With respect to this attorney general, again, I am not his advocate. I am not speaking for him, but I think his position is the following. I don't need to appoint an attorney to represent the Commonwealth in this matter because those exact same identity of interest are being adequately represented by other counsel who will be serving as adversaries in federal court. I think that's the reason, but it's only, I think, learned speculation.
One final question, Mr. Speaker. Would the gentleman yield?
Will the gentleman yield?
Yes, Mr. Speaker, I will yield.
Gentleman yield.
Can the gentleman cite for me any instance in American history of either a state attorney general or a United States attorney general not just deciding not to defend a statute, but aggressively attacking the statute formally? Not just my personal opinion, Mr. Holder saying I don't like this, but him going into court, or any of his predecessors going into court to attack a federal statute or the federal Constitution.
Mr. Speaker, I would tell the gentleman the case that comes to mind is the one that you referenced a moment ago. Prop 8 in California, the state of California and its chief executive officer, the governor, said, I will not defend this particular action, and he listed a myriad of reasons why he would not defend it. I think that is exactly the same thing that General Herring is doing in this case.
Speaking briefly to this, Mr. Speaker.
I will get back to you.
Thank you.
The gentleman from Henrico, Mr. Farrell.
Mr. Speaker, I rise for a motion.
Gentleman may state it.
Move the pending question.
The gentleman from Henrico, Mr. Farrell, moves the pending question. As many as favor that motion will say aye. Aye. Those opposed, no. No. Pending question is called for. Pending question is, shall the bill be engrossed and passed to its third reading? As many as favor that motion will say aye. Aye. Those opposed, no. No. As many as favor the motion will raise the right hand. That's sufficient. The bill is engrossed and passed to its third reading.